they've gotten a lot stricter on what you actually put in the document to make sure that you are actually giving consumers the correct information with very specific details of how and when you're using their information.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, privacy attorney and consultant Irene Moe talks to us about Expensify's privacy policy. With the company recently in the news for the CEO's political emails to users, she covers general principles, rules specific to jurisdictions like California and the EU, and how to create a culture of respecting consumer data that goes beyond the legal documents. It's a great example of turning drafting quality into quality implementation for your client. So, let's tear it down. Hey everybody, welcome to the Contract Teardown Show. I'm Mike Whalen. On this show, we hang out with smart friends like Irene with the purpose of breaking down contracts and documents that are on the interwebs. Irene, how are you today?
I'm good.
It's another day. It's just another day, okay? We are amidst the apocalypse. We're figuring it out. We're learning things. So what we're going to do today is talk about a document. Let me show you the document we are going through. This is the Expensify privacy policy, and we'll talk about the overview of it and the fact that it's super hard to navigate visually. But first, I want to ask you, Irene, what is this document? When are we going to see it? Why should we as drafting lawyers care about this thing?
So this document is important because it is what gives consumers notice that you are using their information, you're collecting their information, and the purposes that your company is using this information. And recently with all the different states and then the EU coming up with their privacy laws, they've gotten a lot stricter on what you actually put in the document to make sure that you are actually giving consumers the correct information with very specific details of how and when you're using their information.
We're using this specific one from Expensify because hilariously, the CEO, I think his name is David Barrett, sent an email out to literally everyone telling people who he thought you should vote for, which in this very split America easily offended 30% of his user base and maybe violated some privacy rules. So we're using this one to talk about a bit what happened there, but more for drafting purposes. How do you write this in a way that CEOs don't go off the deep end and threaten your entire company? Irene, why am I talking to you? What's your background? Tell me a bit about you, and then we'll get into the document.
Yeah. So I am a senior associate at Alita Consulting. We are a boutique privacy and data security firm. So I am a consultant, so what you might hear here might actually be a little bit different than what you hear from an attorney. So we, instead of giving legal advice, which, sort of tends more on, CYA, making sure to avoid every and all risk, we look more holistically at the business and do business risk. And of course, because I am an attorney, standard disclaimer, nothing I say here represents my company, and these are all my personal opinions, but basically that's what I do. I look at the business as a whole, evaluate your risk, and then give you advice based on that holistic view.
This is like the visual version of a retweet. I don't like anything in the thing I'm retweeting. I haven't even read it yet. I'm saving it to read later, so don't hold Irene accountable. It's the visual retweet. All right, here's what we're going to do. We're going to go through specific sections of this document, but first I wanted to give you a chance to talk about the overview of the thing. When you look at this document, this is intended for consumers, right? This is consumer facing. So if I'm writing this and formatting this, I'm trying to get it read. Do people actually want to read this thing when you look at it?
No, absolutely not. I think last December, it was the whole California consumer privacy rush. So I think you remember probably getting, an email probably from like every single company you signed up for that was saying, we updated our privacy policy. For those who didn't do the whole, GDPR update, a lot of them had to do the California, consumer privacy update. And even then, the companies that were affected by the GDPR, they still had to update specifically for the CCPA because the statutory language is a little bit different. So, when we were getting these, I was at holiday parties and people were like, we're getting all these emails. And I'm like, yeah, I'm the one that writes all those
things. It's your
things
fault.
People don't read, but, with me in particular, I do take into account that consumers are going to see this, and I want to make this as readable, as friendly as a privacy notice can possibly be.
So going into specific sections, I'm looking down at number 6 in this document, and it's titled The Use of Your Personal Data. And it's got a bullet point list, and under that some paragraphs. And the list is fairly long. It's fairly inclusive, talking about what they can do with your data. But you wanted to talk about a couple of these that refer to promotional communications. I'm seeing a bullet point that says, to send with your consent or where a friend has referred you to us, promotional communications, also hard copy or electronic newsletters or surveys. There's all the standard stuff that you would think. I'm going to identify you as a member. I'm going to give you support. But talk to me about this marketing material line and why that kind of thing is written so expansively.
Sure. So actually, in my opinion, if you look at the Expensify sort of like bullet pointed list, I think that this is a lot more narrow and discreet than I would usually draft it. I would usually do broad categories like, to communicate with you about our products and services, and then maybe give a couple of examples. And then, I'd say for marketing or advertising, and then give another set of examples. The way that this one is drafted with such an extensive bullet pointed list, it sort of gives the impression to the reader that these are the exact discrete activities that we're using. This is like the whole set of them, which sort of, very narrowly limits the scope that the company can use the information for. With that being said, though, the marketing and the newsletter and promotional information, that is pretty broad. The FTC, they take marketing promotional information very broadly. Where they do get angry is where a company tries to pass off marketing or promotional emails as a transactional email. And that means emails that are related to your account. For example, verifying your identity or, contacting you about certain features that you have, billing, stuff like that. So the FTC can disagree with me. Their word is supreme. And, if they say something different, like nothing I say here matters because it's FTC's world. But where they get mad is, when you try to pass off the commercial email as a transactional email and, you don't include things that, are disclosing that this is like an ad, or you don't give people the unsubscribe option. Because that's the thing. Companies are free to, not provide their service to you if you choose not to receive any emails from them, including transactional emails. But if it's a marketing or promotional email, you have to give the consumers a way to unsubscribe from those.
Yeah, and I'm looking through on the paragraphs that are below the bullet points, and it talks about we may also use your personal data to send important notices to you. So to your point about the specificity of this particular list, that it seems like they've got this list, and then they sort of try to go back and make it broad again. If I'm, for the purpose of making sure that I'm doing the CYA, right? If I'm the lawyer and not the consultant, and I'm thinking about the CYA. You seem to be saying that it would have been better had they sort of kept things broad from the beginning, and would you not have put a bullet pointed list like this in the first place?
No. So I think, using a lot of like headers, subheaders, bullet points lists, those are sort of what makes it easy to read and friendly. What I would have rather than done is, have that paragraph that sort of lists what they do. And then you see how they use the word such as, where it's sort of more like an example of what they do within that category of activities. I would have rather they kept it sort of general like that, so that you are giving, broad categories and meeting notice requirements. But, people know that like these are just examples of stuff that you're doing within that category, and that, this bullet pointed list is not the exact things that you do.
Yeah, I was wondering because later they get into a bunch of disclosures for specific jurisdictions. So I'm looking down at the Europe disclosures in 15. It says jurisdiction-specific provisions, and it talks about Europe, and we'll get into some other ones. But I'm looking at this, and it says participation in the Privacy Shield, application of the Privacy Shield framework and Privacy Shield principles. Here they start getting more specific. Is it possible that the specificity early related to, these other jurisdictions require something more specific, so let's go ahead and give it for everybody, and then do these few European disclosures? What is there a relationship between what those jurisdictions require and the overall document? Does that make sense?
Yeah, no, there is. So with all these different jurisdictions coming out, and especially with the state-specific ones that are a little bit more, volatile, they have a little bit more leeway to make amendments, very quickly versus the GDPR in the EU, which is this, broad, sweeping law that covers the entire EU. There's more leeway for like volatility with the state-specific laws. So what a lot of companies have done is either provide very specific and like segmented rights and notices for specific jurisdictions, or what they've done is sort of have the general privacy policy act as a floor and then provide additional notices that, give additional protections to those consumers in those areas.
That's interesting. So you might have done the opposite of what they did, meaning keep the overall document, because it's the floor, as general, and then give the specific disclosures for the jurisdiction, as opposed to, let me go ahead and make an exhaustive list and try to include everything, and then my California paragraphs are really short.
Yeah, it actually depends on the company and the information they collect, and then their risk in each jurisdiction. Gotcha. So it sort of looks like for here, their biggest risk is the EU, because that specific jurisdiction-specific notice is the most expansive, whereas, later on when we look at all the other ones, they're just like a couple paragraphs. So it just depends on the company and where their risk lies with their data.
Yeah, speaking of, tell me about there was something interesting under the California disclosures. There's a paragraph that says, we adopt this notice to comply with the CCPA, and any terms defined in the CCPA have the same meaning when used in this notice. And then they have a definition section. This is what we mean in terms of California law. Why do you know why that's required? Why have a different definition section for California specifically?
So California has the CCPA has a lot of sort of, I would say, terms of art where they use different wording and definitions than the GDPR, for example. Those are the two big laws that everyone is mostly concerned about. And the reason why it's different is because, the responsibilities that are defined in the CCPA versus the GDPR is different depending on how they classify your company. So the reason why they include that is because, the statutory language in the CCPA is very specific. For example, they talk about sort of the way that you can use data as, business or commercial purposes, whereas in the GDPR, you would say legal basis. So those are the different types of terminologies that, really define what you can do within those laws.
I'm looking through, there's different pieces of the California, they talk about collection, use, and disclosure of personal information. There's quite a few paragraphs. Anything else about California that we should know if we're drafting, that we make sure we add sections like this if we've made sort of a generalized contract and then are focusing on California?
Yeah, I would, for companies that I usually work with, I would usually recommend that they also include the CCPA specific categories of information that you collect. I don't remember specifically if the Expensify one does include it, but sometimes that's again as easy as giving examples. For example, identifiers are your name, email address, or if you're collecting job applicant information, then you might have professional or educational information. And again, that's your work history and your skills. So just giving that very specifically for CCPA is what is like the typical recommendation. But again, if your company doesn't face that much risk in California, relying on the general privacy policy could also work for your company.
And then finally, they've got one in Australia. But again, I think to your point, we're seeing a lot of this pattern where we say, okay, our document, these disclosures are sort of the floor. We're going to do the minimum for each jurisdiction, and then we're going to use our document to be used as widely as possible. And for an international company like this, it sort of has to be. So I want to get to principles, and in that, I want to talk about a little bit what this CEO did. And you tell me if you're in the position where you're the lawyer in-house trying to control this kind of thing. So this CEO, when this happens, was the founder. And at the time, when you're the founder of a little bootstrap company trying to raise money, you can do whatever you want, right? But when you become CEO, you're an employee. And so I'm wondering, for the purpose of this kind of drafting this kind of document, how do you set the CEO and the other people up in the company so that they don't do things that could get them in big trouble in all these jurisdictions, right? It's not just that you wrote the thing, it's that people have to incorporate it in their brains.
Right. So, specifically for, the GDPR, there are 6 legal bases that you can process information. So you would want to make sure that whatever you list in your notice, that your company is aware of that. So, before a new product or like a new feature launch, you'd want to have it set up where if your company isn't in the habit of doing what we call, data protection impact assessments, which is sort of assessing the privacy risks associated with the new product or feature, that at the very least, like the product team or the feature team is at least reaching out to the privacy attorney and saying, hey, this is what we're thinking about doing early on, and I think this is something that's echoed with all in-house attorneys. We want to be brought on like as early on as possible so that we're not the no person at the end. So that's, sort of goes to beyond drafting these governance documents. You really want to build a culture within the company that is privacy focused and what we like to call privacy by design, where you are building in privacy into these products, into these processes, so that it's not an afterthought where there's, a scrambling at the end where we're like, oh crap, are we doing something with consumer data that we're not actually supposed to be doing?
Yeah, I'm assuming, to your point, that a document like this, which is public facing, might be just the outer bounds, but then internally as a company, you've got to define some point short of that so that we totally avoid getting to that outer bound.
Right. So this, notice, it's to consumers. So what would accompany this would probably be an internal privacy policy that lays out the specific policies and procedures of what you can do with data and, sort of like what the acceptable uses are, what the unacceptable uses are. But again, beyond these governance documents, like we can draft them and we can sort of help a company implement them and build out these policies and processes. But if the culture change isn't there, right, if people aren't willing to actually respect consumer privacy, that's not on us. Like we can draft the best ideal state and work with a company to get there. But, if there's no culture change, then, egregious uses of consumer privacy is just going to be continued to happen.
So, because I'm curious, did the Expensify CEO, in your opinion, violate the privacy policy of Expensify or any of these relevant laws, do you think?
I don't think so. I think the way it's written
hot take.
I mean, I don't think it's a hot take. I mean, I think there are multiple ways that, if their attorney had to answer to a supervisory authority, whether it be the FTC, or one of the supervisory authorities in the EU, I think there are multiple ways that this notice is written that would cover their, political emails being sent out from the company. Yeah, this one was, it definitely got out in the ether. If you look at Twitter, it seemed like everybody in the world received this email.
was pretty had strong feelings one way or the other. Well, I appreciate you talking to us about it. It is such an interesting lesson in lawyers do the thing where they write the thing, and then you've actually got to go implement it with human beings. So it's an interesting tale. We'll have all these resources available at lawinsider.com/resources. Irene, if people want to get in touch with you to learn more about what you do and examples like this of practical lawyering, what's the best way to reach out to you?
I'm on Twitter, and then I'm also a good way to connect is on LinkedIn.
Awesome. We'll make sure that people have links to that. Remember, it's lawinsider.com/resources. And if you want to be a contributor on the Contract Teardown Show, just email us. We're at community@lawinsider.com. We'll see you guys next time. Thanks again, Irene.
Bye.